Hi, I'm Kim Rathbone from Rathbone Group, and this is on subrogation. Today we're in Palm Springs, California, and we're at the NASP 2019 Litigation Skills Conference. I'm joined here today by Joel Radakovich and Patrick Jarosch from Grotefeld Hoffman. They spoke today on the best offense is a good offense. Thanks for joining me.
Thank you for having us.
Thank you.
Can you tell me about your presentation today?
Sure. The general gist of our presentation was rather than waiting for the defendant to bring a summary judgment motion late in the litigation, it can sometimes be advantageous to move for dispositive motions proactively as the subrogating plaintiff at an earlier stage to dispose of those issues earlier rather than later.
That's good. Give me some examples on when that would work well.
One of the number one examples is you just go down the list of affirmative defenses that are asserted against you, and there's going to be a few in there. In ours, it was limitation of liability clause, indemnity clauses, latches, statute of repose. All of these present different issues that you can definitely find a way to move on if the law is favorable.
With what types of things would you move on with regard to those topics?
So we would move to strike an affirmative defense, and that really begins before you even file the complaint. You want to kind of tailor your entire case to go in that direction if you think it's a case that might be warranted in. So working with your expert really closely, you can get an affidavit from your expert to support that motion down the line. And that's one of the real benefits of doing this is that it saves time and money. So an affidavit in light of a deposition can be really helpful. So there are a lot of different aspects to how to do it, but in general, I would say starting early and working methodically towards your goal of winning on summary judgment.
So you're lining up all of your facts ahead of time, probably even thinking about it before you file the complaint, and then moving ahead.
Yeah, definitely. In this case, our presentation was largely a case study of one case we worked on together with Scott Futrell, our co-presenter, who's not here, but in that case, it was two specific affirmative defenses that we knew from early in the case, pre-litigation. We knew that it was going to come down to those two issues, so we decided let's just get them taken care of on our schedule as opposed to the defendants.
Tell me a little bit about those issues.
Yeah, so there was a limitation of liability clause which limited or tried to limit the defendant's liability to $500. It was in an inspection report on the back of it was...
Essentially, they called it a contract, but one side was an inspection report. Flip side was, boilerplate, language. Most of it trying to absolve the inspection company from any type of liability or, having to defend the case in any way. And so, that's how we identified early on that was going to be an issue if we were going to file suit. So.
And there was also an indemnity clause in that same language, which basically meant we had to indemnify the defendant for any liability arising out of their services. And so if we had to pay for our own damages, that just doesn't even make any sense. So that would have destroyed our case completely. So we knew that was going to be an issue as well. And so, from the beginning, we just knew we had to deal with those issues, and we thought moving on our own would be a good idea. And
what was the basis for the motion?
So the basis of the motion essentially was that we found state law that in a few different ways said that the exculpatory clause, limitation of liability, was going to be against basically the public interest. And in this being that it was a fire protection issue, and fire code is regulated by the state, and so that really helped us there. And then on the indemnity clause, like Patrick just said, it was having us pay for the defense of the case that we're bringing, which really made no sense. And again, we found favorable case law before we started that we knew or hoped that the court was going to go that way.
So tell me what happened.
Well, we won on both issues. I think I mentioned in the presentation it'd be a little odd if we presented on a case we lost. But the court granted both summary judgment on both issues, basically for the reasons Joel just mentioned. Specifically with the limitation of liability clause, the court did not like the fact that this was a regulated industry that they're basically trying to contract their way out of. And then the indemnity clause, the circuity of obligation, us having to indemnify them for our own claim against them just kind of didn't make sense. And the court agreed, and that's basically what they said.
That's a huge success.
Thanks.
Tell me how the expert affidavit was filed in that case as well.
So the way we used that was we needed some facts to support this, and there had not been depositions. One of the big things is trying to save money in bringing this early motion, and so we hadn't got to expert depositions. So we needed Scott to say enough things that we need to put in our motion and rely on. So we not only used Scott, but also our insured, a few of their employees, and got the exact facts we needed and the basis to bring our motion, support it, and help get us the win.
That's wonderful. Well done.
Thank
And
you.
good
Thank
job
you.
on your presentation today.
Thanks.
Thank you.
Thanks for joining us.
Thank you for having us.
I'm Kim Rathbone. This is on subrogation. That's the long and short of it.